Hey, everybody. My guest today is Dr. Travis Hreno, and we're going to talk about jury nullification. All right, Travis, why don't you introduce yourself?
I'm Dr. Travis Hreno. I am a associate professor of philosophy at the University of Akron. My specialty is philosophy of law, and for the past 2 decades almost, I've been focused on the issue of jury nullification specifically.
Wonderful. Thank you so much. So I have never heard of that term before, jury nullification. Can you just give me a brief summary of what that means?
Sure. Juries, of course, are supposed to return a verdict based on the evidence they hear in court. And that goes back to what we call the deliberative division of labor. What happens in a court is the judge is supposed to be in charge of the law. They inform the jury of what the law is. The jury then determines the facts of the case. Did the defendant actually perform the act in question? If the defendant performed the act in question, and the judge explains that that particular act is illegal, then the jury is supposed to return a verdict of guilty. Now, jury nullification occurs when a jury genuinely believes that the defendant did, in fact, commit the act in question, and that the act in question genuinely is a crime, but nonetheless decide to return a not guilty verdict. And that's a powerful phenomena in the law, based on the combination of 2 legal principles. One is double jeopardy. So for the most part, defendants who are found not guilty cannot be tried again. They're basically free to go. The second is jury independence. So if a jury decides to free somebody, even though the bench, the courts decide or are of the opinion that that's inappropriate, or sometimes they use the term a perverse verdict, they don't have any power to vitiate it. The verdict must stand. Not guilty verdicts can rarely be impeached. Only very rare cases. And the court not agreeing with the jury is simply not a justified reason to try and impeach a not guilty verdict.
Wow, that's interesting. I didn't know that juries had that power.
Just to sort of intervene, I hate to interrupt, but they can't help but have that power if we want an independent jury. An independent jury means, above everything else, that they are allowed to return whatever verdict they want, even if the bench disagrees with it. And again, there are certain boundaries on that. We don't let jury independence work towards the detriment of a defendant. So guilty verdicts that are so-called perverse can be vitiated by a trial judge. Trial judge can simply say, look, I don't think there is evidence to support a guilty verdict. I'm ignoring the jury's verdict and rendering a not guilty verdict. That can happen. But to overrule a not guilty verdict, the standards are incredibly high, and it happens very rarely.
Wow. Okay, so it only works in the defendant's favor.
Yes. Jury nullification only counts as nullification if it's a not guilty verdict. And that's because the effect of that particular law on that particular defendant has, for all intents and purposes, been nullified. That defendant can never be held accountable for that particular action in that particular jurisdiction.
Okay. Wow. Thank you for that.
Verdict. Yeah. Now, somebody who is found guilty when they ought not to have been, say, the contrary position, or a contrary situation where a jury finds the defendant guilty, even though they believe the defendant to be not guilty, isn't nullification. That's simply, we call that an unjust verdict. And, from the history of jury trials, we've always had mechanisms, as it were, to address unjust verdicts.
Yeah, so now that you've explained it, it does make some sense, because if the jury couldn't act independently in any way, what would be the purpose of the jury, right? If the judge already knew what the
rubber stamp it. Yeah.
That's right. If the judge already knew what the law was, the judge can just kind of decide for himself or herself, right? So that makes sense to me. So can you explain to me why a jury would, rule in favor of the defendant, even though they understand and admit that the defendant is guilty?
Yeah, there are a number of reasons in the literature. They kind of classified amongst or along 3 sort of divisions. So the first is general nullification, where the jury is of the opinion that there's something wrong with the law. The law ought not to be, or this action ought not to be a crime. We saw that happen apparently a lot during the 1920s, Prohibition. That resulted in a lot of jury trials with not guilty verdicts where seemingly the evidence was quite damning. And again, speculation there is that when a person is being judged by a jury of their peers, and most of their peers are also drinkers, which pretty much everybody was in the 1920s, despite Prohibition, you're probably not going to get a guilty verdict. So that's the prototypical example, or the the most paradigmatic example. The jury disagrees with the law. The second sort of division is when the jury is fine with the law. Yeah, in general, that sort of activity should be a crime, but they disagree with the punishment. So they kind of think, okay, well, we can think back 10 or 20 years ago when marijuana possession was still considered a much more significant crime than it is now. There was still a lot of people who thought, like, there's no way I'm sending a 20-year-old kid to prison for 15 years because he had a joint in his pocket when he was arrested. And so even though they might be of the opinion that the marijuana laws are fine as they are, they might disagree with the punishment. And finally, we might see a situation where jurors think, okay, the law in general is fine, and the punishment prescribed for violations of that law is also in general fine. But in this particular case, for this particular defendant, we ought not to apply the law. So we can imagine a situation, I always imagine a situation where, say, somebody is driving under the influence. They get into an accident. They don't destroy any property. They don't hurt anybody, but they get into a bad accident and they end up, say, a quadriplegic. Now, technically, they've broken the law, and technically they should be tried for driving under the influence and causing damage and so on and so forth. And I suppose we could see some overly ambitious prosecutor trying to take a case like that to court. But I also imagine that in that sort of situation, the jury might think, like, look, the natural law has taken over here in dishing out punishment. There's nothing we need to do to this defendant to discourage them. There's nothing we need to do to this defendant to discourage the general population. This person's situation is a good enough example. So again, that would be the sort of situation I imagine where a jury might use sympathy in order to render a verdict that goes against the evidence and the law.
Okay, so it sounds like to me that these are just three different versions of the jury exercising their sense of morality.
Yeah, we can call it their discretion of conscience, if we want.
Do you know how often that actually happens?
Well, there's no way of knowing for sure. There's, juries don't issue written decisions. Moreover, juries who do nullify probably don't want to make any sort of public announcement. And I think the most important factor in this is that jurors who do nullify probably aren't aware that they're nullifying.
Does that mean that nobody knows what motivated these jurors other than the jurors themselves?
Yeah. Jury rooms can't be monitored. Of course, that would violate the idea of juror independence. The jurors are free to talk about what went on in the jury room afterwards. For the most part, that testimony is considered to be of very low quality by the courts. And the idea is that once a juror leaves the jury room, they're exposed to all sorts of information and evidence that was withheld from them in the trial, so that they would be able to render a verdict purely free from undue and extra legal influence. After the court has dismissed, they've rendered the verdict, and they enter the real world, as it were. They're now basically liable to infection, as it were. And their status as a juror they don't have a status as a juror anymore. So their testimony about what went on in the jury room can't necessarily be trusted. That's the court's sort of official position. So we really don't know. A lot of people speculate that the O.J. Simpson trial, criminal trial, was an example of jury nullification. I'm not convinced of that myself. I think the defense did a really, really good job of portraying the LAPD as corrupt. So corrupt that they couldn't be trusted to tell the time of day.
Okay, so it just sounds like a lot of speculation, right? Like, I feel like, can we just ask the jurors? Like, maybe the courts don't, find that to be, important or something like that. But just in terms of like research, right? Like, we can just ask the people who are in there, like, why did you vote not guilty, right? I feel like some of them would just be very upfront and honest with this. Like, we just think the law is unjust.
Well, studies have been done with mock juries that reveal that depending on the instruction that jurors are given, they will respond differently to their latent and undisclosed ability to nullify. So if they are told specifically that they have the duty to render a verdict only on the evidence, but they have the power to render a verdict on the evidence and the law, we find that those mock jurors tend to nullify, at least statistically, a little more often than those who don't. And surprisingly, they tend to nullify more robustly in situations with more significant crimes, drunk driving being a prime example.
Interesting. Yeah, so okay, that leads to my next question. Are all jurors informed that they have the power to vote not guilty, even though they're convinced that the person committed the crime?
No, they are not. Every jurisdiction in the U.S. that has examined the case, and not all jurisdictions have examined it, but every jurisdiction that has examined the case has rendered at the appellate level or higher that the nullification instruction, as it's called, is not to be given. And the nullification instruction is just when either the judge, rarely, or the defense attorney is allowed to inform the jury of the phenomena of jury nullification. And it's case law that they're not allowed to do that. Regardless, that still happens at the trial level. Still, to this day, trial judges will sometimes allow defense attorneys to argue either directly or obliquely for jury nullification. Most of the time, those cases go to appeal and they're overturned and sent back to trial. So that's the law. The law is that jurors definitely have the power. The courts can do nothing to intervene in that power, but they have no duty to, and in fact, a duty not to, inform jurors of their power.
That just sounds weird to me.
It is. It is weird.
It's like, why, if they have the right, why don't you have a duty to inform them of their rights?
Well, the idea seems to be, and this is what I find oddest about it, is the idea is that the ideal or virtuous juror is an ignorant juror, is somebody who is not fully aware or informed of their legal role as a juror, because they actually do occupy a space of discretion, just like police officers occupy a space of legal discretion. Prosecuting attorneys have a great deal of legal discretion. Trial judges and appellate judges have a great deal of legal discretion. They're all aware of the discretion they have. Moreover, imbuing all of these actors in the legal system with the discretion that they have doesn't seem to result in any seriously negative harms, at least from the point of view of a functioning legal system. There might be systemic racist harms, but that's not a factor of discretion. That's a factor of how it's used. I would say that it seems very odd then to focus on the jury and say, out of all of these actors in the criminal justice system who have discretion, it's important that we hide this discretion from the jurors. And then that makes you wonder, well, why? Why ought we to hide this discretion from the jurors when we don't hide it from any other actor in the legal system? And seemingly, the only viable answer would be that we can't trust jurors to use their discretionary abilities in this regard in a responsible manner. Now, if that's the case, my view is that that's actually just an attack on the jury system. That's not an attack on jury nullification. that view is predicated on the view that jurors are not to be trusted. Jurors are not responsible. Keep them ignorant to keep them pure. And again, to me, that's a remedy that you adopt for a system you consider to be broken. So I just always think anyone who launches that sort of criticism at nullification really is just saying we ought not to have a jury system. And that's a very problematic view vis-a-vis considerations of liberty, democracy, citizen participation in governance, and so on and so forth.
Yeah, that makes a lot of sense. I feel like the only reason why you wouldn't tell somebody that they had a particular right is because you didn't want them to exercise that right.
Exactly.
Right.
Exactly.
So why, and if you don't want juries to exercise that right, then it does sound like that it's because you don't trust them. You actually think that these particular criminals need to be punished, that they cannot be set free.
Right. And that in this case, what we want the jury to function as a stamp, of approval, as it were. And when they don't, well, then something has gone wrong. We need to intervene so that the jury will always act as a passive sort of, just rubber stamp. Certainly, it's fundamentally problematic that prosecuting attorneys would feel that way. Certainly, I mean, they're part of the executive branch of the government, for crying out loud. They all swear an oath to protect the Constitution, and the Constitution is a document meant to outline the rights that citizens have against the government, not vice versa.
Yeah, well said. So I don't really know that much about the legal system. Again, all I know, it just comes from, watching TV shows and movies and stuff like that. But I'm under the impression...
Highly accurate. Everything you see on TV is highly accurate.
Yeah, I'm sure.
Yeah.
So as far as I'm aware, not every trial has a jury. Is that correct?
No, that's correct. Certainly for misdemeanors, there's no right to a jury trial. Felonies, there's almost always a right to a jury trial. I don't think that's across the board, not universal, but for the most part there is. That's guaranteed in I believe the Sixth Amendment. And defendants have the right in those cases to choose a jury trial or not.
Okay. Do the defendants know that the jurors have the right to nullify?
Their attorneys probably do.
Okay.
Yeah.
So
clever attorneys are going to always try for nullification in situations where they feel that the evidence is somewhat damning.
Okay. So the experts in the legal system, the judge, the lawyers, they all know about it.
Oh, yeah.
But most of the time, the jurors don't know about it.
No. And the defendant probably doesn't know about it.
It just seems like, I don't want to say corruption. I don't know if it goes that far, but it's something kind of close, right? It's like, yes, this right exists for a reason, right? And perhaps we think it exists for a good reason, that juries are independent, right? And so they have these rights, but we're not going to tell them, and we don't really have a duty to tell them because we actually don't want them to be independent. That sounds almost like a form of corruption to me.
I think I know what you're getting at. What you're saying is that instead of citizen participation, what we have is the theater of citizen participation in governance, at least in the criminal law. That's one area where we're supposed to see almost direct democracy in action, is in the jury. And we're setting up certain procedures, certain legal principles, as you were suggesting, to take away that both that jury independence and that participation, and put in its place the appearance of participation.
And in a sense,
can somebody be said to fully participate in an activity under conditions of ignorance? We know that consent, for instance, certainly requires a great deal of information. Consent is dependent on certain epistemic conditions. I think I would say that the same might be said of a juror, that if certain epistemic conditions aren't satisfied, they can't really be said to be participants.
Yeah, that makes sense. And so I would say, I don't know if it's a violation of the jurors' rights, but it's somehow not respecting the jurors' rights. But ultimately, more importantly, it's about the defendant's right.
Well, I'll tell you, I'm writing a book on this right now, and I take a look at views along those lines. First and foremost, I don't think nullification properly described is a right. There is a very complex way of describing legal relationships, first outlined by a legal scholar, Wesley Newcomb Hofeld, in the 1920s. And he outlines a certain legal relationship called legal privileges. One of the things that distinguishes, say, a legal privilege from a legal right is a legal right is a relationship. If you have a legal right, that implies that there is at least one other party that has a legal duty. So if I have a legal right to X, then that means, by definition, there has to be some other party that has a legal duty to me vis-a-vis X. So back to the original question, is jury nullification a right? I think you're correct. If nullification is a right, if juries have the right to nullify, then they have to be informed. And my argument is this, that jurors become aware of their duties and responsibilities qua jurors vis-a-vis instructions from the bench. They don't come in to the jury room with a knowledge of how to be a juror. As a matter of fact, if they do, they'll be excluded during the voir dire process. We want basically blank slates as jurors. That's the ideal. So they don't come in knowing anything about the jury process. Everything they know about their responsibilities is supposed to be told to them by the judge. Now, if one of the things that they have as a juror is a right to nullify, and they're not told by the judge, then we can say that essentially this is a constructive denial of the right. And so that would be a violation of their right. Now, I don't think that's the correct way of viewing it. My argument takes probably about 35 pages of my book so far. But I don't think that that's the correct way of viewing it. Now, we could say, well, what about the defendant? Don't they have a right to a jury that can nullify? And they don't. They have a right to an unbiased jury. Now, an unbiased jury has the ability to nullify. So they certainly have the right to a jury that has the freedom in the grand sort of scheme of things to nullify. They have that right. But they also have a right to a jury that is able to return a not guilty verdict. They don't have the right to a jury that will return a not guilty verdict. So just like they have the right to a jury that has the ability to nullify, they don't have the right to the jury that will nullify.
Okay, thank you for that. So I guess I want to get a better understanding of the motivations behind the different actors in the legal system, okay? Because you would think that ideally what people want to do is uphold the law. Hopefully the law is just, right? And so no matter who you are, that is going to be your ultimate goal. So if you're the judge, that's just what you want to do, right? So if you're motivated by that, why would you not want the jurors to nullify?
Well, it is seen by many people as a fundamental violation of the rule of law. The rule of law is this idea that we're all supposed to be judged by the same laws. If one person commits a crime and gets sentenced to a certain amount of years in prison, another person committing the same crime should receive a correspondingly similar punishment. And when this doesn't happen, it's seen as somehow some kind of fundamental violation of the rule of law. We've seen that for a long time in people who criticize the criminal justice system as being procedurally racist. They say that the outcomes of the criminal justice system are fundamental violations of the rule of law because it's demonstrative of the fact that the law is not being applied universally, equally, and without bias. And so the rule of law objection to jury nullification just says, if we have two criminal cases, and in both cases, the evidence is identical, and the charges are identical, But in one case, the jury nullifies and returns a not guilty verdict. And in the other case, the jury doesn't nullify. They behave the way they're apparently supposed to and returns a guilty verdict. Then what we have is a violation of the rule of law. The law is not being applied equally by actors of the legal system, because while jurors are jurors, they are actors of the legal system.
I see. Yeah, that makes sense, because you want there to be consistency, right? It's almost like there is a rule of law, just like there are rules of physics. There are laws of physics, right? And like if you input the same initial conditions, you should have the same outcome.
Right. Now, I'm actually not convinced by the rule of law objection at all. And the reason why is that I think the rule of law, fundamentally, if we take a look at why people endorse this particular principle, and there are people who cash out the rule of law into many more sub-principles. All of the research, all of the justifications around why the rule of law is something any advanced society should try and instantiate in their legal system boils down to considerations of liberty, that in a society that instantiates the rule of law, the citizens can enjoy the most amount of liberty, the maximal amount of liberty consistent with everybody else's. And that's because the law provides a consistent framework for guiding one's activity. I can function as a rational chooser, knowing what the legal consequences of my actions will be. Now, that seems great. I agree with all of that. But notice the justification here for the rule of law is that the rule of law promotes liberty. Well, it turns out so does jury nullification. Jury nullification, by definition, can only free somebody. So jury nullification promotes liberty. The rule of law promotes liberty in a different way. So there might be some kind of formal conflict between the rule of law and jury nullification, but substantively, they achieve the same ends through different means. The only difference is the rule of law is ideally supposed to grant liberty to those who deserve it, whereas jury nullification just grants liberty.
Yeah,
grant liberty to people who are, by definition, guilty.
Yeah, I can understand this maximal liberty concept. But do you also not think that there is this concept of equality, right? Like, it's not just maximizing people's liberty, is that I'm a person just like any other person. We're all equal, and so we have to be treated the same.
I'm going to suggest that for a lot of people in a lot of situations, jury nullification might appear exactly to endorse the principle of equality. It's because the law only looks at the action. But for a lot of people, what happened prior to the action and the action, what happened after the action, these are all morally and causally relevant concerns. It's not for the law. For the law, what we want to know is, did you do this particular act? Yes or no? Did you have a guilty frame of mind when you committed that act? Yes or no? That's really all that's relevant to considerations of guilt. Considerations of character, so on and so forth, come in at the sentencing stage, but not at considerations of guilt. Given that everybody's situation is unique and independent, something my wife likes to say often is, you don't know their life, which is a good thing to say to me as a philosopher. I can tend to be kind of judgy, but I think the law does not allow for truly nuanced judgments, and it can't. It really, really can't. The jury system is, it's been described as a release valve to the pressures of the law. And I think that's a good way of seeing it. There are times when the law demands X, but justice demands not X. And that may not be the case for a different defendant facing the same charge under similar circumstances.
Yeah.
Now, we may not want that in a legal system. That's something to debate. But I think there's something to be said about having some relief at the seams, as it were.
Yeah, I think that's a fair point, because unlike the laws of physics, I guess the laws of human behavior are perhaps much more complicated, right? Like you cannot compare two people and say that they started with the same initial conditions, right? Their lives are different.
Every hydrogen atom is essentially identical. And I don't think you can say the same thing about people.
Yeah. So then that's why it wouldn't be a violation of equality, because for it to be a violation of like people's equality, it kind of assumes that we were equal situationally to begin with.
Right.
But if we're different,
and from the law's point of view, the initial conditions may be identical for two defendants. But from a jury's point of view, taking into account much more things that we consider to be extra legal considerations, the two defendants may not be in similar initial states at all, and thus judging the appropriateness of their actions will be completely different.
I always thought that law was more, I guess, direct and straightforward than philosophy was, right? It's almost like you have philosophers who are in their ivory towers and they're talking about what's right and wrong, and they can do that for thousands of years. But at the end of the day, we have to figure out how we're going to live with each other, right? What laws are we going to pass? How are we going to uphold these laws? How are we going to punish people, right? And so law was kind of like an application of philosophical thinking about ethics and justice, And so in that sense, I thought, well, because we just kind of decided that this is the right thing and this is what we're going to enforce, it kind of circumvents all the complicated debates in philosophy that philosophers like to engage in, But as you're describing jury nullification, it seems that they're inescapable, actually. Like, even though we have these laws and we're not necessarily debating the justice of these laws every single day, like what a philosopher would do, there are still these complicated issues that really require philosophical thinking.
Oh, yeah. Yeah, well, even as Gödel demonstrated, even math, you can't do math without suddenly doing philosophy. One of the things that really attracted me to philosophy of law, oddly enough, was I got my first degree in jazz guitar, and I wanted to be a jazz guitar player in my 20s and was really into it and loved it. And one of the things about studying jazz is very, very theory rich. And you're supposed to take these theoretical ideas of improvisation, of motivic development, playing ideas against chord structures and so on and so forth, and make something creative and interesting out of it. And sometimes the songs themselves just draw out great creative ideas. Other times the songs are just sort of a blank canvas for you to write on. But the point I'm trying to get here is that jazz seemed to be this sort of almost structure of rules created kind of by fiat. Certainly, they weren't discovered, carved in nature. And within this set of rules and principles and concepts, many of which are sometimes inconsistent or not at least wholly consistent, you have to try and construct a vision. You have to try and construct a theory, an idea. And unfortunately, I was never very good at that, which is why I'm not a professional jazz musician. And also, trying to be a professional jazz musician in Canada in the early 21st century is really an uphill battle. So I went back to grad school for philosophy, which was sort of my first love. And that's when I got into philosophy of law, because I found in law the same thing I found in jazz, a set of not wholly consistent rules and principles set up almost by fiat, and not at the same time, and not by the same people, and not following the same vision. But somehow there's this whole cloth of law, and within it, there are all of these questions that are generated that need to be answered. And to me, that was really what's fascinating. It's too easy in philosophy sometimes to go down a rabbit hole and then go, geez, I don't know. That's a tough one. I'd need to read, Quine for 2 more years before I could even crack that nut. Judges do not have that luxury. It doesn't matter what interesting philosophical properties and principles of causation might be involved in a case. A judge at the end of the day just has to say guilty or not guilty if it's a judge case, and a jury has to say at the end of the day guilty or not guilty. These ambiguities have to be solved, and every time an ambiguity is solved, that creates another stitch in the fabric. And so I think of law in a similar way that I think Quine thought of the mind. It's this web of belief. I see it as this web of principles and rules and guidance, not wholly consistent, but as you get closer to the core, there's more and more consistency and more foundation.
Thank you for that. So do you think that jury nullification is necessary in our society, or do you think it's also like conceptually necessary? No, wait. Let me start that over. Do you think jury nullification needs to exist only because we live in an unjust society? Like, if society were just, would we just be okay with the rubber stamping of verdicts?
Well, first I'll answer in a question you alluded to. Was jury nullification conceptually necessary in that could we have the jury system we currently do, but just remove the power to nullify? And the answer to that is no. It's just built in. There's no way we could have an independent jury that has the power to render verdicts, independent of influence from the bench, and the principle of double jeopardy. As long as we have these things functioning, we're going to have jury nullification. Regardless of how one sees it, it's undeniably true that at a minimum, jury nullification is an emergent property of the jury system, of pretty much any independent jury system, not just ours. I think it's more than a mere emergent property, but it certainly is at least an emergent property that is inescapable. Now, is it in some sense legally or politically or morally necessary? I mean, there's that famous old saw that in a perfectly just world, we wouldn't need laws at all. And yeah, in a perfectly just legal system, we wouldn't probably see much in the way of jury nullification, because part of a perfectly just legal system would involve seating perfectly just jurors. To the degree that the jury system is just only as an ideal, which I think even that can be questioned. I think a lot of our current legal standards, principles, and ideals are very far from instantiating justice. But even if that were the case, to the degree that in practice we don't achieve justice, then jury nullification is certainly one of many mechanisms that can play the role of addressing those failures. It's not the only one, but I would argue that in the face of injustice, we need as many tools as we can.
Yeah, that makes sense. Yeah, I guess I misspoke. I wasn't meaning a perfectly just world. I meant assuming if our laws were just, right? And procedurally it was just. Like, would we then need or want jury nullification?
I think there will always be that demand for, again, as they say, a little play at the seams of the legal system. It's just a fact of how legal systems function, certainly legal systems for a country this large, that changes in the law happen far slower than changes in social mores, and that the law will always be behind.
Yeah, that sounds reasonable to me as well. So now that I possess this information, and if I were to admit this in court, would it mean that I could not be a juror?
It wouldn't mean that you couldn't be, but it would mean that you wouldn't be.
I know too much. I know too much about my rights.
Yeah.
Oh, not my rights, but my privilege.
They would just dismiss you.
See, that just seems corrupt to me. You know what I mean?
Yeah, the prosecuting attorney would probably just use one of their, I can't remember what it's called, but they have the right to just toss jurors out without pause. They'd probably use one of those just to toss you out. They don't want potential nullifiers.
So why would a prosecutor not want that, though?
Well, because nullifying will always end in a not guilty verdict.
So
prosecuting attorneys don't want justice. Prosecuting attorneys want guilty verdicts.
That's what I was trying to get at before, the motivations behind these actors, right? So that's what I was saying. Like, if your motivation is justice, right? If your motivation is just that, then you wouldn't mind. You wouldn't care if juries exercise that privilege, right? But if your goal is to punish people, then of course you would care about that. Then you don't want them to know about that.
There's a reason it's called the adversarial system. It's adversarial. It's one person or one side taking one position. You are guilty. The other side taking the other position. I am not guilty. The prosecutor is not concerned with truth. The prosecutor is already of the opinion before going to court that they know the truth. They are concerned with convincing the court that their version of truth is correct.
Mm-hmm. So it's like a debate.
Concerned with reevaluating whether their version of the truth is correct. They're not concerned with subjecting their version of the truth to evaluation. They'd prefer that didn't happen. It has to happen, but they'd prefer it didn't.
Yeah. Are they paid?
No attorney, no prosecuting attorney is ever rewarded for coming up with the most correct judgments. They are rewarded for coming up with the most, or for generating the most convictions.
You mean like that's how they're paid?
Well, not how they're paid, but how they are promoted and so on and so forth.
Okay. Well, that's kind of like getting paid, right?
Yeah.
It's a way of, they're financially incentivized to punish people or to get guilty verdicts.
Right. Yes. Yeah. As part of, I'm sure if they had some kind of equivalent merit evaluation, that would be one of the metrics. And again, the metric isn't, did we arrive at the correct verdict? The metric is, did we arrive at a guilty verdict?
Yeah, that really bothers me.
Yes, for a prosecuting attorney.
Yeah, it really bothers me. I think that gets to the point at what makes me so uncomfortable about this whole issue is that it's very opposed to, I guess, the motivations of philosophers. Well, at least, it's a totally opposed to what my motivations are when I do philosophy, right? Like, I want to get to the truth, right? And when I talk to somebody else about ethics, I want to get to the truth. I want us to participate in a collaborative project, right? It's collaborative. I'm not battling you, right? I'm not necessarily trying to convince you that I'm right. Sometimes I am, but it's not adversarial. It's not confrontational, right? And so I will, I would do what I need to do in order to best attain the truth, right? Mm-hmm. And if that means maybe just like rethinking what I've said or what I've thought before, then that's great, right? That's what I need to do. But if you're coming in,
that's our life as philosophers, really.
Yes. But if I'm coming in there, just like, no, I know what's true. This person did something wrong, and I just want this guy to be punished. Oh, but there's this other evidence to consider. Oh, no, I already made up my mind. I know it's true. We need to get this guy to be punished. There's this privilege that jurors have to nullify. It's like, oh, no, well, I'm definitely not going to let them know that because that goes against my interests, right? And the interest should be justice. The interest should be truth.
Should be. Yes, I agree. But again, we don't have that sort of system. There's also sort of the social fact of the matter that judges, for the most part, are probably biased towards the prosecution. This is the importance of a jury. Juries don't have lunch with the prosecuting attorney or with the prosecuting attorney's boss, or they don't meet them on the golf course, or they don't have even meetings in the office to discuss the case. This happens, with prosecuting attorneys and judges and their work, their workplace associates. There is some kind of social cohesion going on there that I'm sure has to result in some kind of implicit bias. Statistically, it certainly appears that way. Now, having a jury which does not have any of those social connections, presumably doesn't have an implicit bias one way or the other. Again, that's what the voir dire process is supposed to filter out. I think gives the defendant a very powerful tool in the pursuit of a just and true verdict.
I feel like a lot of people would be very upset if they found out about this, right? Because think about it in the case of cops, right? So let's say you get pulled over and you get a ticket and you don't really think that that ticket was just, okay? Mm-hmm. Now, perhaps there is a system for you to fight that ticket, but the cop doesn't inform you of that, right? Because again, the cop doesn't, well, let's assume in this hypothetical, the cop doesn't want you to fight it. They don't want you to go free. They want you to be punished, right? They want you to get the ticket. In fact, the more tickets they give out, the more likely they're going to get promoted, right? And so that sounds like a corrupt system to me.
Well, it is corrupt in that situation, we have an explicit constructive denial of a right. As long as nullification isn't a right, we can get away, or the courts can get away with denying its existence.
So it's not a legal right, but would you say that it's a moral right?
No, only because there are instances of juries, in like Emmett Smith type trials of, the murder of civil rights workers. And then they find people who are accused of murdering these civil rights workers in the 50s, and they go to trial in some small rural town in Mississippi, and they're found not guilty despite the evidence. That's a situation where we see jury nullification operating based on purely racist motives. And I don't think anyone ever has the moral right to let racist motives determine their actions.
Interesting.
Circumstances.
Yeah, no, I think that's a good thing to bring up, right? Because if it's discretion, then they could use it unjustly as well.
Oh, yeah.
What do you do about it then?
Well, there's a couple of things to be said. One is that's just always been happening anyways. That's just the way juries have been functioning in this country, which is why we have racist outcomes in criminal trials. So what we should do is maybe start informing jurors that they have this power so that all jurors can operate that way. So it can operate that way in situations where we have jurors who are persons of color judging defendants who are persons of color. There's a scholar called Paul Butler who actually makes this explicit argument. And he says that given the racist history of the criminal justice system, Black jurors should use the power of jury nullification to free Black defendants for nonviolent crimes. So Paul Butler is actually saying, yes, racist nullification happens. We just need to double down on it. Or not racist, but race-based nullification happens. Rather than preventing nullification, what we need to do is bring it out in the open. The best disinfectant is sunlight.
But doesn't that put a lot of faith on jurors?
Well, it does. I think it puts a lot of faith more on the jury system and particularly the voir dire process. But one of the things that is supposed to occur during voir dire is that jurors who display any racial bias are supposed to be removed. As a matter of fact, jurors that display racial bias during deliberations after the jury has been seated, after the trial has taken place and they're now deliberating, those jurors are to be removed as well, and their verdict vitiated.
So are you... No, go ahead.
Oh, sorry, not to interrupt, but just so, there are procedures in place that are supposed to sort of respond and redress inherent racism. Whether they're effective or not, I don't know if that's true. I don't know if there's any way of measuring. But I do think that the solution of just removing the discretion altogether from the jurors is not the right way to go about doing this. Probably the right way to go about doing this is educating jurors.
Okay, so that's what my last question was, like what your recommendations are. So it sounds like you're saying we should educate jurors that they have this privilege, but it shouldn't become a legal right.
Well, I'm actually going to back up a little bit here. I was certainly exploring a train of thought, but I myself don't think I'm willing to endorse the nullification instruction. With mock juries, I mentioned before how they responded to jury nullification instructions. One of the unexpected results was that occasionally mock juries will interpret the nullification instruction to mean that they can convict in situations where the law would demand a not guilty verdict. That does not happen in similar trials or mock trials when the nullification instruction is not given. So it seems to be that the nullification instruction is causally related to jurors convicting defendants who are accused of morally heinous crimes, regardless of whether the evidence would support it. So when we have jurors who are accused of, say, child sexual assault, for instance, jurors are much more likely to render a guilty verdict if given a nullification instruction than if not. And in monitoring these mock juries, they noticed that the jurors who had the nullification instruction tended not to deliberate on the evidence.
That's interesting. Why do you think that is?
And I think that's a problem. I think what that says is, to my mind, is that there is some kind of correlation between nullification instructions and unjust convictions. So while all of the good things about jury nullification that we've been talking about exist, the nullification instruction, which is a separate thing from jury nullification, the nullification instruction has some measurable negative consequences. And I think it's possible to enjoy all the benefits of jury nullification, the play at the seams, as it were, without the jury nullification instruction. And the reason I say that is no jury nullification instructions were given to juries in the 1920s. And yet through their actions, they were able to voice the citizenry's disapproval of prohibition laws in a direct, active way that wasn't able to be done through the ballot box.
Okay, so is your recommendation to keep it as it is now?
Unfortunately, I agree with all of your principled objections to keeping the jury in the dark. I've expressed them myself today in this discussion, but there are pragmatic reasons, I think. Just like I think there are pragmatic reasons to put certain constraints on the discretion that police officers and prosecuting attorneys have. Though we don't have those sort of constraints, there should be. And why? It's because police officers aren't angels. Prosecuting attorneys aren't angels. They're human beings with all of the flaws that human beings have. They don't have just virtues, they have vices. And jurors, if they were ideal jurors, should be told about nullification. They should be able to play that role of injecting a little bit of mercy into the strict letter of the law. I think from a moral point of view, from a political governance point of view, from an economic point of view, from a hedonistic point of view, that's all justified. That would be ideal, but we don't have ideal jurors. We have very flawed jurors. And out of all of the actors in the legal system, arguably jurors are the most flawed in that they have no professional responsibility to do their job well, and they have no accountability.
Thank you for that. I think it's a good place to wrap things up. Thank you so much for this discussion. It was fascinating. It was very educational. Yeah, you're very welcome. It was educational, a little bit infuriating, a little bit depressing and disheartening, but
welcome to philosophy, right?
Yes, it was still an enjoyable conversation.
Yeah, well, thank you very much. I enjoyed it quite a bit. I always like talking about this, of course.